And let's pick up where we left off on Monday, which was looking at the trends in case selections. Again, there's a massive amount of appeals. I'm going to walk out of the frame here again because we're going to look at our textbook for some visuals. There's a massive amount of cases that are appealed to the Supreme Court through that process of a writ of certiorari, but the Supreme Court only takes that 1 to 3%, given depending on the year, and I keep emphasizing 1% here. So that obviously, I think, given such a narrow range of cases that make it, it leads to the question: well, why do they take the ones that they do? How is it that you get your case heard? And we talked about some of the trends so far, like a difference in opinions between the lower courts. If you've got those 11 geographically based appeals courts on the federal level, and they're all giving different verdicts, that needs to be reconciled. If the court feels like they've made a verdict and it is being misapplied, the court deliberately built in, Frankfurter deliberately built in the with all deliberate speed in Brown v. Board, but as the court began to really watch certain states in districts like Henrico County go well beyond what was intended there, they practically advertised for a case so that they could clarify that all deliberate speed, that all the time for all deliberate speed came and went. So if they feel like their verdict is being misapplied, if there is an instance where they want to wade in on a particular issue, okay? One of the other things I was pointing out is that interest groups play a role. Remember, when you guys did the unit on interest groups, we talked about 70% of interest groups used litigation as a strategy because, again, it is highly effective, especially if you have somewhat limited resources. You're lobbying less individuals on some level. There's you've got to sway, 5 of the justices, and what was unconstitutional suddenly becomes constitutional immediately, as long as you're not Brown v. Board. It vests immediately. So interest groups in general do play a role, and certain ones that have maybe a greater kind of not name recognition, but reputation, I suppose, like the ACLU or the NAACP certainly get noticed. A key figure to get noticed, though, and this is where we left off, was the Solicitor General. And while he may be the fourth he or she may be the fourth within the kind of chain of command of the Department of Justice, you get the Attorney General first, and then you go through a bunch of basically kind of not assistants, but second and third in commands. You get to the Solicitor General, but what makes this person unique is their unique role of actually doing the oral arguments in front of the Supreme Court, that they're there to present the government side. So they kind of play a unique role. They may be a party that's directly involved, but they also are combing through those writs of certiorari, those requests, to see if there's something unique that the government wants the Supreme Court to look at. So when they wade in on something, the Supreme Court kind of picks its head up. So while they may be fourth in the chain of command, they're kind of referred to often as the 10th justice, because when they speak, it carries kind of volumes, and the court notices. This term is familiar. They may do it directly. They may do it indirectly as a friend of the court through an amicus curiae. Amicus meaning, amicable, friendly. So they may do it directly or indirectly, but either way, the court notices. So speaking of, again, maybe I could have shown you at this beginning. Again, this whole question is interesting because of the decrease in the number of cases that the court is taking. If you find that book under your desk, or wherever you left it, page 263, we'll show Allie. There it is. All right? And if you had to identify a trend here, oh boy, wouldn't that be an easy essay question, right? What is the trend? What's happening with my green line, my green bar? What's happening with the numbers there? It goes up. and then you say, give me my 5, please. What would you have to do if this was, actually, I mean, they do. They often ask for trends. So you wouldn't just say it goes up. You would do what? Kind of next.
You just prove it and say
Yeah.
it went from 1,181 to 9,000.
Good. You'd support it with some numbers just to kind of, give your evidence. It's a seemingly minor thing, but I think it speaks volumes that way. What's happening with my red line? My red bar? Katie, what's happening with that? It's going down, and then you would cite kind of by how much. So there we've got a little bit of proof for the fact that, you notice this trend, that, you do see a reduction in the number of cases that the Supreme Court is taking. It leads to the question as to why. And I alluded to some of this earlier as well, that, there may be, how many more speeches, cases involving speech do we need to look at? Have we really kind of worked out where the limits of speech end? Where your right to speech ends and someone's right to, their interest picks up, right? What we've defined is any speech that leads to imminent lawless action. Imminent. Do we need to keep working on that? In terms of what do we mean by a right to an attorney? Do we need to keep working on that? Or have we got the idea that you need a qualified, competent attorney that's present at the both investigatory and court phase? And if you can't afford one won't be provided for you. Do we need to work that out anymore? So we may have, over time, worked out a lot of those issues. And we're still struggling with, let's say, privacy or the role of money in politics. But we've worked out the most of them. Maybe. That's, I think, has a lot of appeal, that argument. There is also increasingly, because we talked about efforts from the executive branch on down to get ideological, again, let's see if you guys can do this. I talk about the Supreme Court a lot, and then I pointed out on Friday that oftentimes this focus may be misplaced. Why do we spend too much focus on the Supreme Court? Where should we be looking if we're worried about the role of the courts and how it, may go under the radar? I got 9 justices. How often do I have vacancies, right? Where should I be looking? Paul?
At the lower state.
Yeah, how come?
Because there are a lot more of them.
Good.
Set up precedents.
Yeah, so there's a lot more of them. There's a lot more vacancies there too, right? So we've got a lot more courts and a lot more judgeships and a lot more openings. If you remember the bar chart, you looked at how many did Reagan and Nixon get to appoint? Supreme Court justices. Do you remember? It was a pretty high number. Sydney looks close. She's going to take a guess.
No.
She's shaking her head no. I will not take a guess while there's a camera running. Haley, do you remember? No? David? There you go. He gets the prize for the day. Reagan was kind of the tricky 3/4 because he had an appointment that was already on the court, Rehnquist, who became a Supreme Court justice. But 4, right? Do you remember roughly the numbers to the lower courts? Just, ballpark it for me. Was it like 8? You remember? 10s, 20s? Katie's close, I can tell. What column am I in? Hundreds. Yeah, it was in the hundreds. It was up to like 800, 900 in some cases, right? So they make a lot more appointments to the lower courts. Again, if 1 to 3% of the cases make it to the Supreme Court, that means the bulk of the decisions are happening on the lower courts. So not only are there a lot more appointments to be made, but a lot more policy to be influenced because that's where the bulk of the decisions are being made, right? And then again, what happens in terms of these positions when the president leaves office? Do new people come in? Haley shakes her head no. So they represent a legacy, right? They're going to be there continuing to carry out the president's policies long after, all right? So maybe good that we went over that. We seemed a little shaky on that. But the whole reason I went back over that is the idea, remember, you may not have remembered the importance of all of that, but presidents sure as heck do. And so they've come up with systems to make sure that they have an ideological consistency on that lower court. We talked about Reagan and him giving surveys and interviews and making sure that he got his lower court appointments right. And over time, there was an ideological consistency from the bottom up with his courts. Okay? Some of it, we'll see it in a minute when we talk about the process of deciding cases, might be explained by this risk aversion that, and I'm going to talk about the clerks. These, I joke about them as interns. They are highly educated people with impressive resumes and pedigrees, but they are essentially kind of, doing the initial almost like intern work for a Supreme Court justice. And, if they pick a case that turns out to be counterproductive to the court and its standing, well, I suppose that they feel the pressure of that and the embarrassment of that. So, the clerks themselves have to be careful about, hey, what case am I actually bringing to the justice to consider here? I don't want to overreach and therefore look bad myself. Similarly, the justices, over time, realize that they need the implementing population. They need the public. They need the president. They need the court, the Congress. They may be a little risk averse. They may not be looking to rock the boat too much. Their standing depends on their reputation. So risk aversion may explain a little bit of the downward trend. Regardless of the downward trend, we got to understand the process for deciding a case. For this, again, I want you to look just real quickly at page 264. We'll help Allie out at home from the comfort of her home there. That. All right. So, this gives you numbers again, and it gives you somewhat of the process and the flow chart that you may want to follow as we go along. Process starts with the submission of briefs. Not boxers, but briefs, right? Oh, good. I woke you up on a Monday. So briefs are anything but. They are the written argument that the court wants to put together. It includes their, legal rationale, and they work out to be hundreds and hundreds of pages long. Those briefs are kind of similar to how Congress relies on the written record, right? Everything that's said on the floor is typed in the congressional record. It saves you from having to go to the floor, to have to go to committee meetings. You can have, in this case, clerks, or in the case of Congress, interns or legislative aides pour through it and give you a synopsis. So this, is for efficiency. Even though they're hundreds of pages long, it saves you that, putting forth all of that argument in a verbal form and having to have the justices sit through it. They can, use a kind of a division of labor to get more efficient. We do, however, it is important to kind of have that face-to-face contact and to make those oral arguments. What's striking about it, and I should play it for you at some point, you can go and listen to it in terms of the audio recordings. They often have, again, this is part of our judicial process. It ought to be transparent. We just don't bring cameras into the Supreme Court, but there's audio recordings. And, this seems to me some of the most stressful kind of, legal arguments to be made, because you've got 30 minutes. You are literally held to a clock. There are 9 justices obviously sitting there, and they are of some importance and power and prestige. You're probably intimidated by them. They're great legal minds. And in the middle of your argument, which is a prepared statement, they will likely pepper you with questions and just kind of throw you off track. So it's actually, kind of interesting and exciting to watch. But you'd have to go searching for it in terms of the audio. Once they've heard oral arguments, what they do is they go into a huddle. They go into a judicial conference, and they'll discuss. There's a schedule for it. I don't think you'll ever get asked about it, but there is a schedule for it. There's a rhythm to their calendar, just like Congress has a rhythm. And what's important to note about the judicial conference is they will try to come to a decision, but the decision is tentative. So what was striking about Brown v. Board, remember, it all came down to the timing of the case, which got brought. It was like one of the last parts of their session, and then you had a stroke that necessitated a new justice coming in, Warren, who completely changed the argument from a legal issue to a moral issue. So, history turns on a dime. And so the schedule of the court in that case and the fluke of someone getting, ill changed the outcome for Brown v. Board. hopefully we would have got there one way or another, but it certainly sped the process of desegregation. So kind of keep in mind, they were in that judicial conference phase. They hadn't come to a decision, and they had to wait till they reconvened with a new justice to kind of get to their final decision. All right, the final decision happens when they do arrive at a consensus. So they're going to tentatively vote, but they don't come to the final consensus until the argument is actually written out. I mean, would you agree to something kind of verbally in principle without seeing it in writing, knowing that what we're discussing is legally binding? So I want you to think of it the same way. That okay, I agree to this in principle, but I want to see it in print. I want to see exactly how you phrase things before I put my name on it and it becomes legally binding. So keep in mind the writing is incredibly important. It can sway things in one direction or another. You write the verdict, with a little too much leaning one way. Maybe you're giving the government expanded powers beyond what we were originally talking about, and you may kind of, get some justices to jump ship. Okay, so this writing is important, and it is one of the powers of the Chief Justice, assuming they are in the majority. If the Chief Justice is in the majority, being the Chief Justice, they have the authority to say, well, I'll write it, or I'm going to assign it to this person who's in the majority. If they're in the minority, they're in the minority, and they kind of cede that power as a result. Terminology, you guys would. Like we see these maybe as multiple choice kind of questions. And again, hopefully the language helps you sort it out, that it's, majority opinion. Oh, good, I can get that one right. That's when you've got a consensus here. You've got a majority of the court agreeing on not only the decision, but its legal rationale. So kind of keep in mind, there could be two different things here, right? I might agree that we need to desegregate, but I may not agree with the legal rationale as to why. You might be going into the 14th Amendment's Equal Protection Clause. I might be going into the Privileges and Immunities Clause. We both got to the same place, but we got there different ways. And if that's the case, you'd write a concurring opinion. I concur, I agree, but I have a different rationale. And so, if we're a little more unanimous in terms of verdict and rationale, we write a majority opinion. If I want to set up a different argument for it, and I feel like it's important because it clarifies something in the Constitution, or it, gives it a better legal rationale, I write a concurring opinion. A plurality opinion is when you've got everyone kind of all over the place. I've got multiple justices agreeing on the verdict, but multiple justices disagreeing on the legal rationale. Okay? So if one wants to jump ship, it's a concurring. If multiple ones have arrived at the same place different ways, we write a plurality opinion. To kind of skip, these are weighty decisions. They set precedent, and precedent is binding on the court as much as any law or constitutional provision. They have to kind of really, see around corners to break from precedent. That having been said, these all kind of have maybe wormholes in them, because if you don't have unanimous consent that you see kind of in this final verdict, it opens up the door for a minority opinion to become next day's majority opinion. So this is perhaps the most powerful of the verdicts, the per curiam opinion, which I didn't say correctly. This is unsigned, and the court is speaking as a single body, meaning we're speaking as one. Remember, Marshall moved them from that seritum practice of every justice kind of giving their own opinion, and then it's like tea leaves. You kind of read into it and think, well, I think this is the verdict that they came up with. When the court speaks as a whole, man, does it carry weight. And if they're doing it unsigned, it removes any idea of, well, that's Rehnquist, or well, that's Judge Roberts. That's you can kind of maybe not invalidate a ruling, but kind of begin to read personality into the verdict and see it as something different. This is a unanimous voice, right? And when you have that, it makes it harder for, like I said, the dissenting opinion to take root. Warren knew he needed a unanimous court for Brown v. Board, because if he didn't have it, then the rally cry, the dissenting opinion was going to be the rally cry for states and for people that didn't want to implement this. So this negates the dissenting opinion argument. Okay, so that that writing is critical because, like I said, it can cause people to jump ship, and as a result, it takes a while to do it. But once they've got it written, it could be weeks, could be months. Not quick to write these things. Then they'll announce, and once they've announced, that kind of that's when, like I said, something becomes immediate. We announce the opinions, and what we've read as a constitutional guarantee vests immediately once we do the announcements. All right. Another thing that you're curious about then is like, okay, we know the mechanics of how they made an opinion. What was the rationale for this opinion? How do we get inside the heads of the justices and understand why they rule the way they do? One of the things I said that, really is probably the biggest tool that you'd use to figure out how they make decisions is the legal factors. But what I mean by that more specifically is they look at precedent. Stare decisis is let the decision stand. So decisis is decision, stare is stand. They really have to adhere to this. If they don't want to be bound by a past decision, like I said, they have to kind of see around corners. They have to, find something within the case that makes it seem unique. One of my first jobs coming out of college was I was a paralegal for a law firm. They dealt with international trade cases, which sounded really exciting at first and turned out to be mind-numbing as it went on. Because all that we ever did was, okay, here is Taiwan, they're making sweaters, and they seem to have an unfair competitive advantage because the government is subsidizing the manufacturer, and they're bringing in sweaters, so cheaply that American producers can't compete. And so we're going to, cite that this is unfair. To prove the case, we find a case where China did the same, and the United States Trade Representative ruled against them. It's called scope. If we're defending the Taiwanese company, then we find a case where the government ruled in favor of them. Again, it's scope. This case is like that case, and therefore you should rule the same, or this case is different than that case based on this unique characteristic, and therefore you should rule differently. That's a lot of the legal process, to be honest with you. Find a case that either lines up and therefore gives you a guideline as to how to rule in this case. These two cases are the same. Or find something unique about it that gives you grounds to rule differently. And so in the case of trying to break precedent, you're looking for something unique, right? Precedents can also be broken, though, because they're unworkable. So Brown v. Board with all deliberate speed is a great example of something being unworkable. Dred Scott became unworkable. We had changed over time, and it was no longer something that we could justify. So things do become kind of outmoded, outdated, unwise from a policy standpoint. We can't implement this anymore. It's flawed. Basically what this allows you to say is that earlier court was so influenced by the time frame, their own, maybe inherent prejudices that this is unworkable. We can't uphold this anymore, given the modern understanding of the Constitution and modern societal norms. Okay. Regardless of how we get there, if we're looking for something that is unique or unworkable, if we're trying to say, okay, I'm going to overturn a precedent, you still rely on law, you still rely on the Constitution, you still rely on the context of history and a knowledge of what it means to implement this. You don't pluck it from nowhere. You've got to ground it. Okay. Another guideline to why people rule the way they do is their legal philosophy. And again, I think those videos that we've been watching are really good to let you understand that justices think differently about the law. You would think that it's black and white, but it's not. You can look at the law and how you are to interpret and uphold it differently. So for some, they come in with a philosophy of judicial restraint. The great example of this was Oliver Wendell Holmes, who, it was a line, I forget what they said in the video, but basically he could, basically it was like he could care less. If a legislative branch wanted to do something, and it was the will of the people, who was he as a justice to kind of get in the way? Right? Who are these 9 unelected individuals who serve for life to get in the way? The job of the court is to not get in the way of the democratic process. That they have to act with restraint, that they have to let the decisions of the other branches stand. And it's only when you cross the line in terms of, not adhering to the Constitution do they weigh in, all right? A strict constructionist, you might say, okay, they're the same. Someone with judicial restraint or someone who's a strict constructionist might be the same. And no, but there's a difference here. What they look for, you see it as originalism, textualism. They want to be consistent with what the founding fathers wanted. They emphasize restraint, but it's not restraint based on the idea of being unelected and impeding the democratic process. It's restraint to kind of the original meaning and having a fidelity to it. And so they might often, based on this original meaning, be as likely to negate a governmental act as to uphold it. If I feel like the court is, or the government is overreaching, I'm going to smack it down. But if I feel like they're adhering to kind of original intent, I'll uphold it. Judicial activism, that might be like Justice Black, is where they believe they can use their powers broadly to promote things. That they're there to do that. They're the only branch that can do that. Everyone else is politically beholden, and therefore not at liberty to kind of make the bold actions that the court does. That's the whole reason they're there in the first place, is to be in the minority and force the rest of the government and society to kind of keep up with them. All right, so that's your legal philosophy, but that's not your political philosophy, which is slightly different. You might also come in with an idea of like how you rule as a justice, and this is why I think like when Eisenhower talked about, hey, Warren was one of the 2 biggest mistakes I've ever made, and Brennan was the second. He was looking at perhaps the ideological background of the individuals he brought in, but what overrode it was the judicial philosophy, right? Could work the other way around as well. People have attitudes about, the size and scale of government and the role of government. That is separate than the idea of what the court does. So, for example, a conservative justice, they might uphold the government's position on a civil rights case. But they might also rule against the government on an economic case based on their conservative values. All right. Another factor is public opinion. Again, we'll get into it towards the end. The public is an implementing population, and you have to recognize that. So the court relies on the people for its prestige, for compliance, and so the public, hey, you're not going to lose your job over this, but you may lose some of your standing. So there is a recognition of that. Just to kind of show you you would think that the court is isolated from the public. But remember we talked about Webster versus reproductive services, where we first read privacy into the Constitution, and that allowed people to make decisions regarding reproduction, that people had privacy in the bedroom. And carry that forward to Roe v. Wade and other cases involving decisions about procreation, contraception, and abortion. This type of case becomes really politically charged. And so, like I said, since the 60s on, Supreme Court justices face this as a litmus test. If they are not pro-choice, or if they are pro-choice, they both meet the same kind of backlash, just from a different group. Look at Bork. I had mentioned he is one of the first times we oppose somebody on an ideological basis based on his stand on Roe v. Wade and other rights of privacy. 300,000 show up at the Capitol to protest. Now, this is a guy that's going to be unelected. He's appointed and will be confirmed by the Senate and will serve for life. This is, again, a Supreme Court justice. This isn't something you think the public would have an ability to weigh in on, but 300,000 show up to protest, and the mail that goes to the court, I don't know who reads the court's mail. It's like, hey, thanks for writing. They go from 1,000 letters to 46,000 letters. I like this quote from Rehnquist, that judges, so long as they are relatively normal human beings. And when you see Rehnquist, you're going to love that quote even more, because he's this very affable. You're going to like him, but he's kind of this lumbering kind of figure. So for him to say relatively normal human beings is kind of funny. He looks a little like this lumbering giant. He talks about if we're relatively normal, we can't escape being influenced by public opinion than anyone else working in another job. And if a judge were to, I love this, hermetically seal, that's the best way to seal yourself, nothing gets in terms of biological contaminants. If we were to hermetically seal ourselves, we would accomplish very little. He recognizes that we partly work within the public sphere. You want more evidence of it other than the letters pouring in and the quote from Rehnquist. Look at what happens during periods of social and economic kind of upheaval. What you see is it coincides with an activist court. Best example, the New Deal Supreme Court, where they consistently ruled against FDR. And there was a public backlash, and most notably, FDR's threat to do what to the court? What's that famous kind of event called? You guys keep ruling against me, you keep it up, and I'm going to do what to you? Katie's close, but you're going to rest.
Is that the
court packing scheme, right? I'm gonna add a bunch of new justices till I get as many on there as the Constitution is silent on the number. You guys are not responsive to the public need. You better pivot and sway my way, or I'm going to pack the court. All right, and they did. Okay. The other fun thing, and I think the videos do a great job of this, is to look at the idea. You guys are 9 people locked in a room, and you just have to make it through, 4 quarters. You only got 10 more weeks to like each other, and everyone loves everyone. Otherwise, I'm coming down on you, right? That's my philosophy. Everyone loves everyone. But can you imagine being there for life? If all of a sudden, like the bell rings on the final day, you can't go. You're still kind of together. Let's work it out. You're going to see in the video, just pay attention to it. There's a justice named Berger and Sandra Day O'Connor. And they knew each other before they got on the court. It's kind of interesting how it's such a big world, but sometimes you find out these 9 justices have overlapped with each other quite a bit. Personalities definitely play a role. It talked about Warren being the politician and working the halls, walking into offices and persuading people. It talked about Justice Black bringing Warren to his home and sharing, having a steak and a bottle of scotch with him. I don't think the whole bottle, but, they had a glass of scotch together. So that plays a role. And similarly, you might have kind of rivalries develop where you just have this animosity towards somebody that you're stuck with. So there are factions, there are kind of friendships that form, there are kind of voting blocks that form. Certain justices like Sandra Day O'Connor became a critical swing vote. It's kind of interesting. She was brought in by Reagan, wanted a conservative, but also was looking to bring diversity into the court. She's the first female justice. Feels trivial when you talk that way. Thurgood Marshall is the first African American, and Sonia Sotomayor is the first Hispanic, and there's kind of critical watershed moments where we break a barrier. But at any rate, she was a swing justice. So is Kennedy. Real quickly, social background plays a role. Let me show you this for the bell rings if I can. Here's Sotomayor talking about needing diversity, because it brings a different perspective. And what's interesting is Obama kind of talks about how he tries to consider diversity, but how it's a little artificial. I think there's a quote in here from him. Yeah. And I feel good because this is his language, not mine. When I was making my ridiculous kind of, the way I thought about diversity is not to think about any single seat. I've got to fill this slot with this demographic. He has a quote about, looking for, I'll find it later. He literally kind of lists this bizarre kind of, combination of individual. Like, I'm not looking for a left-handed, red-headed Hindu who, speaks 7 languages. I'm looking for what fits the position, right?
300. Take the next one. The next, like,
There it is. I need a black lesbian, from Skokie, Illinois. And I love that he's that open about, hey, that's a ridiculous thing to suggest. Thank you for finding that. We literally have just like a half a page of notes left, and we're done with the courts. Remember to keep working on those study guides. All right, Allie.